I will now call case number 124904. In the marriage of Mary Karanja-Meek and Aaron Marshall-Meek. Sorry for apologies if I misspoke on the name pronunciation.
Joseph Booth appearing for the appellant, ready and for argument.
You may begin your argument if you would like, Mr. But if you need a minute to gather, take that as well. So.
In consideration of the Court of Appeals review of what was effectively a review of the Boutreau case as much as it was of this matter, a lot of attention went to the nomenclature that was used as far as marital and non-marital property. And during oral arguments, we walked between 23-2601 and 23-2801, and that transmutation of individual property during a marriage that's held into marital property and the hodgepodge that we have in divorce actions, and how the court's discretion is broad and how it would have access to all the assets. And they took offense to the Boutreau case in the sense that it talked about separate property in the middle of a divorce action when that's the one thing there can't be is at the initiation of a divorce action, you have this idea that you're going to bring everything in for consideration. But they didn't concentrate on is the 40-year-old social policy of looking at the nature of some of these assets that are part of the marital estate, even those that haven't arrived yet, refer to them as inchoate kind of assets. And those are common across the board, and we see that. But the unique nature of a personal injury award brings in the idea that you're replacing something that was lost some time ago, but that loss is continuous after the marriage, and there has to be some way to determine. And what Boutreau did was it created the rubric, the 4-part piece: purpose of the award, the time period of diminished earning potential, the nature of the underlying industry, and the terms of the award. And the trial court skipped through that analysis, and so did the Court of Appeals. They didn't look at that rubric. Nothing in that rubric takes away the court's discretion on how it's going to do what it needs to do to make an equitable award, but it defines that equity in acknowledging that Mr. Meek's case, he was a survivor of an explosion, suffered debilitating injuries that will last him his life, probably cost him some years off of his life, and continue on. The settlement that they reached had the loss of consortium plus this devastating ongoing loss.
Maybe this is too colloquial, but it isn't the question whether you put that in the big bucket during once the action's commenced, or whether it stays out of that big bucket altogether. Is that the essence of this argument? Meaning that does it go into this maritable property bucket or not?
Each of the cases, Lash, Powell,
Yeah.
and did I answer?
Yeah. Well, I just wanted to get confirmation that that's the essence of this dispute, but I guess not including it in the bucket, I don't understand how that is consistent with 23-2801. I understand the case law, but I guess how does that case law survive scrutiny under that statute?
Because it goes in the bucket. It's how it comes back out the other end. The analytics, you can't make the analytics if you didn't have the bucket.
Right.
And so 23-2801 is a jurisdictional statement. And the way I would explain it is in some other states, the court doesn't have jurisdiction over certain species of property, whatever that may be. And the court just really can't do anything with it. The arguments are whether the court can touch it or not, and then what the court's going to decide. And there may be arguments about what effect that may have. We do it all the time in premarital or gift situations, inheritance. The court knows that it could do whatever it wants to with that premarital asset. Let's say a short time marriage in a house that came into the marriage and was paid for when it came in, you know, that kind of hypothetical. It's in the bucket, but in Kansas family law, we pretty well know that it's going to stay in the original homeowner's control, and all that's going to be really messed with is whether or not there's been some increase in the value during the marriage.
Because that's equitable, right?
Right, right. And this is a discussion on a rubric of how to do equity.
What bothered,
Go ahead.
what bothered me in this case is that it seemed that the district court felt very confined and constrained by the settlement that had happened earlier with the insurance company and said, well, that was just done earlier and so we're going to be stuck with that because of res judicata. What's wrong with that?
It's completely wrongheaded. We constantly bring in, by agreements of one form or another, assets into a marriage. The couple takes assets from wherever and buys a home in the middle of their marriage, and they put it in joint tenancy with right of survivorship. That's a contract, and that binds it. And they have a species of ownership that they've decided in that contract, and the court's not bound by any of that. This couple turned around and took a large global settlement that had no demarcation on what was consortium and what was pain and suffering, et cetera, and made an agreement to have two separate annuities that would pay out over two separate lifespans. There's a lot of good reasons for doing that, including the fact that if you put all the eggs in the basket of this injured man's lifespan, you've sharply reduced the value of the annuities than you would if you added two separate. It's there in the bucket, as you said, and he was also criticized for not considering his share as marital, but did consider her share. Well, if you have two assets of equal value and you're asking for greater than half, that's how you do it.
Can you clarify that for me? Because I got mixed up. Okay, so the district court, did he or she or whoever it was say that both of them go into marital assets?
He considered it, I believe, he used the term separate property. That he separated them out and said, this is their separate property. We're controlled by this original contract, and I'm not going to disturb that. And in fact, chastised Mr. Meek for trying to reach into her separate property and not offering some of his. But if you have two.
And then the Court of Appeals said, what about that?
My view of it was, first they said it's all marital property. Stuck to that 2601 and 2801.
Right.
Kind of logic, but didn't look at the social policy around what was the purpose for that body of settlement.
But if we're saying didn't look at the purpose for that pot of money, don't we just look at the plain language of 2801, which incorporates 2802? I mean, why does that come into play? Because the statute's the statute. It says, even if it's an inheritance, like you said, no matter what it is, it all goes in and then it's sorted out under 2802, the equitable. So why should we even be considering what the intent was when they separate? The intent of a father who leaves his daughter $2 million as an inheritance is that my daughter's going to get that, but it still goes into the pot, right?
Mm-hmm.
So what's the difference?
It goes into the pot, the inheritance, and then I've been practicing family law for about 30 years here in Kansas. It almost always gets set aside because you looked at the original donor's intent.
But that doesn't say anything about the statute. That's just practice in family law in Kansas, but it's not written down anywhere.
Correct.
Okay. So
if if you're looking at relative needs, based on, the loss, generally in a tort case, loss of consortium is much less than the loss that's incurred by someone who has a life-changing, traumatic brain injury.
Mhm.
So these people decided to, when they got the money and the settlement, they decided to divide that in half. So logically, that would mean in her half included a lot of what would have been assigned to his injury. Is that fair to say?
I believe it's an inescapable conclusion.
So then if the judge felt like he was stuck with that, then he wouldn't be able to consider equitably how much, let's say each annuity is at $100,000. He can't consider what's equitable for dividing that pot based on her loss of consortium versus his loss of a traumatic brain injury. Is that kind of what happened here?
It is what happened here.
But can't the district court consider that under 23-2802?
Well, in this case, they effectively said, I can't, and you can't argue this, that you used res judicata as one of the reasons. You can't go back and reshuffle that deck of cards in an equitable division. But like the purchase of a house or other just mundane things that we do in contracts that upset this 2601 issue of this is my separate money and you can't have it, you turn around and throw it into joint ownership, and then you have a divorce, and then it gets broken back out into separate ownership.
Can I jump in and maybe approach the problem from a different angle? What from your perspective is wrong with the Court of Appeals decision?
There were two issues that concerned me, and the first is I believe that the social policy expressed in Boutro provides good guidance to the court without removing its discretion on how to work through a personal injury award. And that social policy, which has been around now for about 25 years and has roots back 40 years.
So you want to preserve a judicially created social policy as opposed to just allowing district courts to follow the statute?
I want both. This does follow the statute, and then
I mean, that's what I'm driving at. I don't see where the Court of Appeals did anything that prevents a district court from following what Justice Standridge just referenced, 23-802C, which lists a whole bunch of factors, which that's policy, but it's legislatively created policy. Why don't we just stick with that? And isn't that exactly what the Court of Appeals did?
The Court of Appeals hyper-focused on this issue of marital, non-marital, and basically put it back in.
Well, wasn't that because you appealed the district court's ruling that it was separate property?
True.
So you won.
Yes,
I don't understand why you're here. That's
Yes.
what I'm driving at.
It is precisely the way that it was coined when I carried the message of the decision. We won, but we need to appeal this. The second reason.
Right. So why? What is it that you hope to accomplish?
Well, the second reason has to do with the fact that then the remand is you get to decide whether or not what you decided was equitable anyway. And how does the court turn around and say, the trial court, how does it turn around and say, I ruled that it was equitable to stick with the original decision?
The Court of Appeals agreed with you and said the district court made an error of law in characterizing the property as separate property. So once there's that error of law, the district court's got to redo it, right?
Well, I mean, the remand really doesn't say to redo it. The remand says determine whether or not it was equitable.
Right. Follow 23-802C.
Right.
And are you asking us to tell the district court to do anything other than follow 23-802C?
I believe the Boutro rubric sets out a social policy, a guidance for the court on how to do that. That's in addition and a subset of.
Okay.
of what we have in the general law. I think it's helpful. It's not only helpful to the court, but it's helpful to the bar as we try to guide settlement. Instead of having it, well, this is just in the wind. If it's in the wind and there isn't any kind of guidance, we're gonna try every one of these things.
Isn't Buteau, I don't know how to say it, the Court of Appeals decision in 2000, isn't it inconsistent with our mechanical approach statute 23-2801? I mean, they specifically say, we're not going to follow that mechanical approach. We're going with this analytical approach, which is not put everything, as Justice Wall said, in a big pot. We have to consider the nature. I mean, to me, it's, that's not on appeal here, but it seems to me that that is completely inconsistent, and you would like to adopt that with the statute.
Again, because you have the statute there as the guidance of what to do. It highlights the analytical approach, highlights this unique nature of a personal injury award that is exactly the kind of story we have here.
But isn't it appropriate to analyze the nature of the award under 23-2802?
Therefore, it's not, to your first question, inconsistent with the statute.
Well, it seems like Buteau says, no, you got to do that from the beginning, not in the 2802. That you got to say at the outset, okay, we're going to separate it. We're not going to have a big pot, as Justice Wall said. We're not going to have a big pot. We're going to start at the beginning by considering the nature, and then we'll go and do, but everybody gets their own stuff, like in my inheritance. Oh, okay, well, that, the father-in-law hated the son-in-law, and so didn't want a penny of that $2 million to go. So we're going to separate that out at the beginning before we talk about under 2802, what is equitable. That's kind of how I saw it.
I see it as being part of the marital estate, therefore under 02, and guiding further, looking at those structures of how to protect the injured party.
But that's what the Court of Appeals did here
Mhm.
in remanding it. So I would just point to Justice Caleb and say, what's wrong with that then, if that's what you're advocating for?
Again, I think the Buteau case voiced a very important social policy to a unique asset of the marriage. These assets, they either come in as a whole, such as a judgment after a jury trial or trial, but they're intended to be satisfying needs that reach past the marriage.
So wouldn't the better place to object to this be the legislature and have them create an exception in a law or have a subsection that talks about that? Why, I mean, it is clear from this statute, and this is what we do. We don't make policy. So even though you've talked about, well, the policy of the district court, courts don't make policy, okay? We follow the law as the legislature passed the statute. So, are you coming to the wrong place to challenge this? Wrong branch of government?
I suppose we fall into the circular argument of it's been there for a quarter century as the law of the land, and the legislature didn't in any way.
Well, I don't know that it's the law of the land. You're saying that it's as a general rule in your 30 years of practice, this is how the courts have done it. But, I'll bet we can find cases, not even cases, but if we rifled through all the hundreds of thousands of, documents at the district court level, I'm sure there's some judges that don't do that.
Oh, I'm sure.
Right.
Can't you argue on remand that the judge is not bound by res judicata? We don't have the same parties involved, for one thing, and that equitably they have the power to divide those annuities differently, and that they should divide them differently. Don't you have the power? Don't you have the ability to do that on remand as the Court of Appeals left it?
Yes, and I believe that happened in the trial itself. That was the core of the argument. And, you know, you can't make the Butro type argument without making that argument. So I get your point in the sense that the Venn diagram is virtually on top of each other.
Other questions? Okay, thank you. Mr. Sternberg?
Thank you, Honor. May it please the court. Again, I'm Jonathan Sternberg and I represent the appellee Nancy Karanja-Meek. Your Honors, you know, I spent a lot of time preparing for this and I was going to start off by a discussion of issue preservation, which the court did grant our conditional cross petition. But because of that discussion that the court just had with my opposing counsel, I'm going to scratch that entirely. I still think the court should weigh that. But I'd like to address some of these issues. Let's step back and start from the district court's perspective. At the time in the district court, it's a trial court. The Court of Appeals, anything the Court of Appeals decides is binding authority on Judge J.R.M. in Johnson County. Judge J.R.M., as the special master saw, as the parties I don't think disputed at the time, was faced with a series of decisions, starting with, you know, Lash and Butow, I'm not sure how to say that either, from the Court of Appeals, which all do say very specifically that that personal injury awards don't necessarily have to be marital property. Well, what's Judge J.R.M., what's the special master, what are the parties to do with that? We have to follow it, right? We're in the district court. We have to follow what the Court of Appeals says. The Court of Appeals, however, when it got here, Judge Hurst and Judge Atchison and Judge Isherwood looked at this and said, you know what? Those cases are wrong. Unlike Judge J.R.M., they weren't bound by those prior decisions. And you know what? They're entirely right. I'm kind of in the awkward position because I was trying in the Court of Appeals to defend the district court's judgment. But then when we got the Court of Appeals judgment, I agree it's right. Now, Judge Stegall, you asked, why are you here to the other side? Frankly, I was the one who could have filed a petition for review on this. It was our position that this was separate property that the Court of Appeals was rejecting. The Court of Appeals, though, I think clearly got this right. This is a statutory question in Kansas. The cases that the Court of Appeals was basing that the prior decisions were basing this not go in the bucket. I think that's a great way to put it, that it's separate property. That's what they specifically said. And that's what Judge J.R.M. says. He says, based on those decisions, the annuities are, quote, separate property that don't even go in the bucket in the first place. The problem with those decisions is they're not based on Kansas law at all. They cite cases from Colorado and Nebraska and Missouri and Illinois and other states. I also practice in Missouri and Illinois. I'm very familiar from doing family law appeals in those states, how it works. There, it's not a jurisdictional issue, it's an authority issue, but you look at a piece of property and first determine whether under the statutes and common law, it qualifies as separate or marital property. If it's separate, it gets set aside to the other side or to the parties. And then what's left is the marital estate that gets equitably divided. Kansas, since 1968, has not done that. Since 1968, Kansas has been what they call, in the Court of Appeals quoted this, a total divisibility state. So all of this, from those old Court of Appeals decisions, from what Judge J.R.M. decided, are wrong. Instead here, the parties' personal injury awards, the future annuities, and it's really just the future annuities that were at issue here, not the underlying cash lump sum awards, which have already been distributed to the parties. That all goes in the bucket and then gets equitably distributed. Why they're here, Justice Stegall, to answer your question, I think, I mean, I like Mr. Booth. I don't know what's in his mind, but what I think the issue is what they want is some kind of overarching direction to district courts that whenever you're faced with this kind of an annuity, it must go, it must be, that annuity must be divided itself between the parties as part of the equitable distribution. What the Court of Appeals held here that they disagree with is, I think, it's not in, they didn't file a brief, is that they said, look, we're going to remand this back so that Judge J.R.M. can take a look at this again under 232802C, apply the 10 factors. But they said as an aside, he doesn't necessarily have to change the outcome. Now, of course, that's a correct decision. I think what Mr. Booth means by saying we want, you know, the court to apply the public policy of Butow is to effectively direct district courts that whenever they're faced with this kind of situation, they must do what he wants.
Can I just interrupt?
Yes, Your Honor.
So I asked opposing counsel about the impact of the Court of Appeals decision. I want to ask you the same question.
Yes, Your Honor.
where I started from was, it looks to me like the Court of Appeals just said, essentially what you've summarized. The decision was wrong as a matter of law, as was all of our precedent. You have to consider it as marital property. And then you go do what's commanded in 23-802C, which is the 10 factors. And do you agree that that's what the Court of Appeals told the district court to do?
I agree 100%.
And you don't disagree with that? In other words, you're not contesting that?
I'm not contesting that. When we got the decision from the Court of Appeals, after the oral argument there, I frankly wasn't terribly surprised that this was the result, because I think both of us were surprised by the tenor that the panel was taking there. But I had a discussion with my client and the trial counsel about, should we attempt to challenge this in the Supreme Court? And we realized that this was right, and this was a fight we should have as a matter of equity back in the district court. Because frankly, if you look at Judge J.R.'s decision, pages 108 to 109 of volume 1, this is, I don't think he actually put page numbers on his decision itself. He uses terms like fair, just, equitable. He felt that this was a fair and equitable result. Now, my opposing counsel just said that, well, in his 30 years of practice in Kansas, take inheritances, Justice Standridge, you mentioned that as an example, that, usually it goes to the party who inherited, who received the inheritance. I had a case just 2 years ago in the Court of Appeals where the husband, I represented the wife, the husband had inherited $10 million from his parents. He was contesting on appeal whether the wife should have received, I think, a total of like $6 million of that. It was a disproportionate amount, in fact, and the Court of Appeals affirmed. I don't think it was Judge J.R., but another Johnson County district court judge's decision that that's how it should be. It's a question of equity, and those 10 factors go to fairness. It goes to the circumstances of the parties. Now, one thing that
Can I just interrupt right
sure.
there? So do you agree then that on remand, under those 10 factors, specifically number 5,
Mhm.
the district court can fairly and equitably consider that personal injury award, what it was for, who incurred the loss, how large the relative loss is, under number 5, which says the time, source, and manner of acquisition of property?
Certainly, it can consider that. Now, there's a couple of things. You had a discussion, Justice Wilson, with my opposing counsel about the quality and what this award was about. And there were a couple of inconsistencies, I think, with the record in that discussion. One was that there was no demarcation in the agreement of who was getting what. That's simply not true. In the settlement agreement, which is volume 13, pages 18 to 20 of the record, it clearly lays out that my client that each party would receive a specific lump sum first for his injury and then for her loss of consortium. And then there would be a specific annuity schedule, which are not in equal amounts. They are in different amounts. In fact, my client's is slightly less than the appellant's of how that annuity would work in total. So
The court isn't bound by that, is it? Because the award was granted at a certain time, and the divorce is granted later. So for Judge J-Ram or any district judge to say, well, I'm bound by that, by principles of res judicata.
So-
There's all sorts of reasons why that's wrong, correct?
So I appreciate that he used the words res judicata. I don't think he was saying that res judicata prevents me from considering the purpose of this. I think he considered the purpose of it in great detail. What he's saying is that certain testimony of the appellant that he found not credible was that he was coerced into the agreement and he was misled or fraudulently induced into executing it. Judge J.R.M. said, I find that not credible, and then says it's also in contravention of basic legal principles of res judicata and fundamental interests of finality, justice, and certainty. He's not saying that that I can't consider the purpose. But I think
Well, finality seems to indicate that he does feel like he's constrained by that in some way. And in fact, under this statute, he's really not.
and I appreciate if that was what he was thinking in writing that, then I agree with you that he's not actually constrained by that. But he can still take it into account. And here, even under the analytic approach cases, I think if there is any public policy that comes from it, it's that when you have an award that's a future award, so here we aren't just talking about some lump sums. The parties already received their lump sums. No one is even fighting over that. The only thing that's being fought over here are the annuities themselves that the parties are now receiving for years and decades to come. In all those prior cases, I think what's interesting about them is they said, so let's take this out of whether it goes in the bucket or not. Let's take it back into who gets it, right? It is marital property. It's got to be divided to somebody. So in the Powell case, the cash funds that the party had received were equitably divided between the parties as marital property, in fact, equal. But there was also a separate future annuity to the husband for his personal injury that was assigned to him separately. And nobody challenged that. Now, while they were talking about separate property, I think the same equitable, considerations come in for who gets it, for who it gets
It
divided.
was separate assignment within the bucket.
Exactly, precisely,
Well,
which of course the court can do. That's the purpose of 2802.
And just to clarify,
Yes,
the issue of who gets the property is not in front of us. Correct?
correct, because that's what the Court of Appeals remanded to Judge J-Ram, and no one has sought review. I agree. But the same thing, the Lash case, the property award was skewed toward the wife because a cash award was to be used for future losses. In Butow, which we keep fighting about, there was a lump sum that was determined to be a marital asset, but the husband's annuity was once again given to him as his separate property. So that can be done. Judge J-Ram can do that still using the same equitable considerations. And part of this is, the other side doesn't view the facts in the light most favorable to Judge J-Ram's decision at all. There is partly a factual consideration in this. When determining who gets what out of that big bucket, who gets these annuities, if a consideration is, and I think it can be under subsection 5, that it's to compensate wife for a future loss. My client testified in pretty great detail at the trial, pages 53 to 54, especially 63, that she continues to suffer the loss of consortium. In fact, the loss of consortium was in large part a reason that precipitated the divorce itself. And that the purpose of this annuity was to ensure that in the future, despite her husband's and now to be ex-husband's disability, the party's children, who she cares for primarily, would have a parent that is there to ensure their safety and well-being and ensure their financial.
But doesn't loss of consortium stop on the divorce?
So
She can no longer, in the settlement, they presumed they would remain married and the loss of consortium would continue until the end of their lives. But with the divorce, the consortium stops for the woman. She was the only one that got that loss. So actually, the prediction at the time of the settlement is going to end up to be different from what the judge considers at the time of the divorce, correct?
I appreciate it could be looked at that, but again, I don't think the judge has to see it that way. So the consortium itself, obviously, if they weren't married and a man, let's say they're boyfriend and girlfriend, and the boyfriend has a terrible personal injury, there isn't a loss of consortium to the girlfriend because there's no marriage. But at the time of this injury, there was a loss of consortium. While my client couldn't bring that claim today, the loss she experienced back then had implications for the future, which is the reason for the future annuity. No different than the fact that his injury occurred at a specific place in time. But the effects of that injury continue into the future, which is why he gets a future annuity as well.
And they may be more or less.
Exactly. That's correct.
The thing I've been struggling with this thing is the reality of the deal is that when you're in the settlement conference and there's a pot of money here to allocate, the first consideration is how do we divide it up so that we avoid taxes? And then, and I've seen all kinds of manipulation of how you might logically divide things up because of the taxes or how the annuities are going to work, which to me speaks strongly in favor of the way the Court of Appeals analyzed this, because it can go back and the court can not presume that the parties had real reasons for putting more money in consortium than lost of wages, which would be a taxable kind of a more taxable kind of event. The court can weigh all that is all we're getting at. And that's why I think the Court of Appeals decision had some pull for me, some persuasion to me.
I don't disagree. And I think as Justice Deagle asked me, is that even before us? I think the back and forth you and I have had, Justice Wilson, and I think, no, it really isn't. This court's not going to give direction on Judge Jairam, how he's going to, exercise equity. Although one thing I'll mention, which my opponent mentioned, is that they were treating these as income to calculate maintenance and child support, these future annuities. And if they're treating them as the party's separate income for that, I think that's another part of the equitable consideration of who gets what. We're going to say that if we're going to calculate my client's requirement to pay her ex-husband maintenance based on her getting this income, and now he's going to get part of the income, I think the judge can find that inequitable too. Seeing that I'm out of time, if there are no further questions, we ask the court to affirm the Court of Appeals judgment.
Thank you,
So
Mr.
let me clarify. You're asking to affirm the Court of Appeals judgment, correct?
Well, ideally, I'd like you to reverse the Court of Appeals and order his appeal dismissed, because I don't think any of this is preserved for appeal in the first place. He never
I
made
understand,
any of
but
these
that's what
arguments.
you're at.
But otherwise, yes, affirm the
I think
Court of
Mr.
Appeals.
Booth is asking for the same relief.
I'm confused by it too. Thank you, Justice Rosen.
You reserve 3 minutes, Mr. Booth?
Well, let's start off, Mr. Booth. Are you asking for the same relief as counsel? You're asking us to affirm the Court of Appeals. Is that right?
No, in the sense of tossing out the Butro directions for the court. I think that the idea that Butro sets out a rubric or a methodology in which you look at this unique species of personal injury awards. They're in the hodgepodge. You're supposed to.
Would you have us make that compulsory? I just, with the statute, how do you, I just don't know what you want us to do with that case law, given the discretion that exists in the plain language of the statute for equitable division. It seems to me like the district court judge certainly can take follow that approach or not. And that's what the legislature has laid out for the district courts.
I think a concern is that the Court of Appeals decision could be taken as don't consider those factors and consider it as any other species of.
Why wouldn't the Court of Appeals decision and ultimately our court's decision, if we affirm it, be taken very clearly to follow the statute? And why is that inadequate from your perspective? And by the statute, I'm talking about the 10 factors in 2802.
There's very little in 2802 that directly shines a light on the unique species.
So we as a court need to supplement 2802. That's what you're asking us to do. I just want to be clear with what you're asking for.
I think that's a fair statement, as is every decision that either the Court of Appeals or the Supreme Court makes when it comments on the effect of a statute. Of the things that I wanted to, one of the last comments of opposing counsel was that they included in the income, the personal injury award. Well, they did include the monthly payments as a construction of what the child support and maintenance would be. But you can't not include those monthly payments and presume that the court's going to rule differently when you look at the definition in child support of what income is. It's anything occurring on a regular from whatever source. And we usually go by the child support number when we figure the maintenance number. They can obviously divert for all kinds of reasons, including other reasons for maintenance. And the court mentioned that it didn't like the maintenance award, but it was going to stick with what the parties had proposed in the pretrial. It did not consider the lump sum awards that come every 5 years, I believe this. I know one's coming in 2025. And those are sizable and went past the period of maintenance. The period of maintenance was only 3 years. So one does not rely on the other. And the lower court sort of saw that as duplicitous or contradictory when the lower court said, you asked for this maintenance based upon this standard, but now you're asking for some of the money that you're getting maintenance from. Well, the court wasn't bound by the proposal of what the maintenance was going to be. So the court could have done something very different in property distribution that would have affected that income stream, and it would have dramatically changed what the child support would be and what the maintenance would be. So there was nothing that bound the court to the parties' joint suggestion on what the maintenance would be. If the court wanted to be bound, it would have had to have been a stipulation of fact or an agreement by the parties that the court determined whether or not it was fair, just, and equitable. The outcome of the trial court's decision has to change. If you look at the reasoning behind the change was bound by the original agreement. I'm not going to consider any other factors. And we'll go back to the conversation here. Whether or not you uphold the Court of Appeals, if you uphold the Court of Appeals in a one-line statement, we're just fine with that. The outcome has to change because the district court's decision ignored any purpose behind that award. And just said the reason why it's fair is because they made the agreement some years ago. And if they thought it was fair, I got to think it's fair too. And I'm bound by the res judicata effect. And that's all I have.
Questions? Thank you.
Thank you.
Thank you to both counsel for your arguments. We will take this matter under advisement.